Both have a constraint for 4:30?
No, not me. So what I suggest, if the panel's minded, is to focus on Amy and questions of her first,
Yep.
and we could do the next steps stuff
After.
with me after.
Yeah. We'll have plenty of time to do that, I'm sure. Right, thank you. So we'll reconvene, and do the panel members have any further questions of Amy?
I'll try and be as quick as I can. So your paragraph 25, thinking about methods, Ms Cheswick has suggested to us that in the text of the methods, a way to distinguish whether something should be in the method or in explanatory text might be whether there are directive steps described in the method, or whether there's some other explanatory thing going on that's not a directive step, and that might be a way that we could slice and dice whether something sits in explanatory text or is part of a method. Does that ring true for you?
Primarily, we don't have the ability to commit council to financial expenditure moving forward, which would include training.
I mean, it isn't something I've considered, but I'd be willing to have a look at how that could look. I guess you're just thinking about how the refined methods have been drafted. They are very much interrelated to enabling the policies, but yeah, I'd be happy to have a look at it and see if there is that ability to split it out.
I think that's the heart of my earlier questioning around what should sit in explanatory text, and yeah. At your paragraph 39, where I believe you are listing all of the things that don't have, this is the gaps. At your paragraph 39, these are places where there are some things missing. And I wondered if this is particularly concerning when I looked at that list and see that historic heritage is there on that list, and I wondered if that was a particular concern given the RMA definition and its link to cultural values.
Yes, so for historic heritage, there is an objective which broadly refers to recognising and protecting cultures of the district, and so there is potential that it might apply to this approach, but I guess that's sort of what I was indicating, is it's not clear, because it is quite broad wording, that if that would be part of this approach or not. So I think because there is an existing objective, there might be an ability to sort of do some refining to it to make it clear if it was to be used.
And then it might be how the historic heritage chapter relates to the what was a CESM chapter but is now Ngāi Tahu cultural values.
Yeah.
And understanding how that works in the plan. Okay. Yep. You mentioned primacy before, and you mentioned it at para 42. So I just wanted to check, is it primacy or is it more like having to read the plan as a whole? And my reason for asking that question is that we've actually had a discussion in the UFD hearing, in that hearing stream 1 around, and Mr. Leckie said it just before, that strategic directions don't have primacy, and there's case law around that, and so we've got this sense that wherever something is sitting in the plan, it's there's no extra emphasis.
Yeah.
Are you happy that the decision around where some of this stuff sits, aside from making it clear to plan users and not causing confusion or having orphaned provisions, but that just that basic idea that we have to read the plan as a whole, does that help with the concerns that you're addressing?
I think in some instances it might. I guess because there has been an inconsistent approach taken across the specific chapters of the plan. And so some of the chapters are really clear throughout your objectives, policies and rules, and within those objectives and more within the policies, it will sort of give a direction around the concerns relate to these particular matters. So I suppose when I'm looking back at the overarching, which I understand you would still read it as a whole, but you're looking at those overarching Ngāi Tahu cultural values provisions, and where there are those gaps, it doesn't give you that same clarity that you would have in those other chapters that have those very clear linkages. So while I understand that you would still look at it as a whole, I just don't think it would address that inconsistency that would come across.
So it's, yeah, okay. And so what you just highlighted there was that it could potentially be a focus in the policies that would be most important.
I think so, yes.
Just going past, you've answered lots of other things. Paragraph 55, is the upshot of your paragraph 55 that the PDP, the one we're about to make decisions on, is an improvement on the operative plan when it comes to managing earthworks? Is that the crux of?
That was my
Yep.
analysis, yep.
I've come to the end of mine. I just want to actually, before I start, I just want to thank you for the comprehensive analysis that you've given us, particularly all of the depth that you went into on the MPS, the origins and intent, and the analysis that has given us a real sense of we're half integrated and half not. Us having that knowledge is a consequence of the effort that you've put in. So whatever happens to the Appendix G and Appendix H and the final detail, we are well assisted by the efforts that you've made. Kia ora.
When I look at the accidental discovery protocol draft, which is your Appendix C, under the heading of in situ Pounamu accidental discovery, and it's got a 1, 2, I think. I've crossed it out and put A and B. In 1, is that copied out of the Ngāi Tahu Pounamu resource management plan? Because I see in 1, in the second line, it says that if you find anything, it should be reported. If we're going to have it in the district plan as a requirement, it probably should be shall be reported rather than be discretionary. And again, at the bottom of that page, the fine should be notified immediately to Pounamu Protection Officer.
Yep. So I think, yeah, this came directly from the plan, so it should be changed to shall.
Now, one of the two of you, and I can't remember which, suggested that there actually needs to be some more work done on that, on the discovery protocol. Some rewording might be required.
Mm-hmm.
Not me, not you. So can I have some confidence in what's showing up there as something that we could include as an appendix to the plan?
That might have been in earthworks. There needed to be a decision made on which of the documents was referred to, so that might have actually been Tina.
I can clarify for Hokanui at least that this is the relief supported and sought by Hokanui, and it clears up that confusion that we had in the previous hearing of there being two.
Okay. The only other questions I've got are things that really we need to talk about rather than pose questions to you.
I realise I've got one more thing. I clearly can't see the green. I cannot see the green.
Oh.
I've tried, I've looked,
Oh,
no, I just wanted to tell me where the green ones are. And
yep.
well, if there's only three, Mr. Leakey said there were only 3 green ones. If I could just be told which ones are the green ones, then I can try and work out why my eyes aren't working.
We can, so there's.
All right, so carry on, but if they manage to tell me by the end of the day, that'd be great.
We'll show you on our copy. So, turning then to returning to where to from here, and I guess is it necessary to have a 2-step process of having a copy of the appendix with cross out and underlined to show the extent of the changes, and if so, how long will it take?
So I just narrowed it down to the chapters which, on my understanding, have had a bit more transition through the hearing process. For me, that is the eco chapter, NFL, and then we also have earthworks and natural hazards, which are still even under consideration. So I'm mindful that what is happening in the terms of that process actually is going to be even more refined for the hearing of 7 March. So perhaps for Appendix G we stick with everything, except that we could probably provide a copy of the currently recommended provisions for NFL and ECO to Hokanui Runanga to then incorporate the Appendix G amendments into it in a tracked way, and then we can all provide those, circulate those. So that's 2 chapters. I don't necessarily have an answer for you in terms of earthworks and natural hazards because of the fact that it actually is happening within the 4 to 5 week time frame. Yeah, I think so at this stage. But if we were to do that in the next week, because it's 2 chapters, so if we could do that in the next week and then give fed farmers that, they could then have 5 weeks from today, which is still their 4 weeks that was originally signalled, that would still be sitting, and I did work it out, but it would be still sitting before, it'd be mid-March, which is well before the wrap-up hearing.
From that, my expectation is that within a week something will come into council that we can then circulate to the others and provide a 4-week period for feedback. So is that what you're saying?
And also I would offer to provide the narrative that we've been discussing to Ms Cook-Munro in order to describe why we are having this further document in relation to these 2 chapters. And it responds directly to what Ms Bennett observed in her evidence, so it is a traceable process, and I can work through any issues that Ms Cook-Munro has with that in terms of the Appendix G. So
if you do it, I think for clarity, the panel through a previous minute and through questions at the previous hearing asked for some information to be provided. The feedback that has come from the hearing today is that for clarity, it actually needs the provisions being altered, being shown clearly, and the panel recognises the opportunity for natural justice reasons to provide these other parties to an opportunity and time to look at it, and those other parties includes the 42A author. So if it was done in that context, it provides a nice, neat package that, I guess from some point of view, the panel is trying to drive this, not individual submitters. And either we can use those, we can prepare those words, or you can.
And certainly if Ms Cook-Munro doesn't agree, then it may be that we come back to the panel for direction, in which case you can make those signals. But I mean, we're also having it in an open forum, which Ms Cook-Munro can come back and have a look at if she'd like to. So in some ways you're relying on me to have that dialogue, but equally if there's an issue that we encounter, then we can put that back before you based on her views and ours.
Yeah, so for clarity, my intent was that the updated copy will come to the panel and we will put it out for feedback, which would remove the need for you to have direct dialogue, unless we can put in the note that that we encourage the parties, if they need to talk to each other.
Yeah, and this is where I'm always offering to do that work for you rather than you having to issue another minute. So, in my experience, most times in terms of process, legal counsel can agree on that, and it's only when we can't that we need further directions from the panel. But I take your point, and I'll get in touch and let her know where we're landing.
Yeah. Anyway, Mr. Leakey.
Yeah, thank you. That I'm broadly comfortable with that. I mean, the ability for us to be able to track in the changes is just reliant on getting the updated chapters. That's my only proviso. I mean, I'm happy with that as a plan. I think equally, Appendix G could be provided to Federated Farmers in its current form, but because I think it's quite usable. But I think, I mean, it is very explicit in the changes it's seeking, and that would maybe simplify things. And the scenario might be for if Hokanui were to provide Appendix G in Word, Federated Farmers could even add a column and provide comments on each rule if that helps. It might be simple.
Well, any of the parties can make use of a vacant column. It's a good idea.
Yeah, then it's just one less
piece of paper.
one less piece of paper, and then that means that could happen sort of quite quickly because that's now ready. And then while that's happening, there's going to need to be this other more broader integration piece around Appendix G and H.
So would it be Appendix D, G, and H?
Yeah, I think then it's the full. I agree. And then really it's delivering what they've sought, which is the ability to provide comments on the key aspects of Ms. Barron's evidence. So that's sensible. So D, G, and H.
Is there any other matter that needs to be raised today?
It might just be the time of the day, but I'm still not completely 100% clear on the broader integration piece. But there's going to be a memo coming around that I'll be able to have a view on, and maybe that's how we'll deal with that. Yeah. Great. No, from Hokanui's perspective, that's helpful. So thank you for your time.
In the schedule, we had time at the end for council just to capture any of the answers to the questions you've made. Would that be okay if we spent possibly 15 minutes on the notes I've made on those catch-ups?
Yes.
Thank you.
So it does enable Amy to depart to wherever, and thank you.
So just a couple of little things first. So in response to your questions yesterday regarding the Charter of Understanding, I should have brought to your attention section 74(2) capital A of the RMA, which, and I've got it up, requires a territorial authority when preparing a district plan must take account of any relevant planning document recognised by an iwi authority and lodged with the territorial authority. to the extent its content has a bearing on the resource management issues of the district. So we talked about the charter being in evidence and available for you in terms of your decisions, but I would also note that 742A is quite clear language in terms of how you...
Can you confirm for me your interpretation there, because it's a little bit different to what I was expecting you to say. So I'll just get to the right place. So you said section 74 to
Capital
A. Yes. Any relevant planning document recognised by an iwi authority and lodged with the territorial authority. Typically, when I've read that phrase, I've thought iwi management plan. So is the charter a relevant planning document or something else?
Councillor Bartlett, we always talk about wording. You're very precise, and maybe that's a reflection on me. Sorry, I take the intent of the provision. So, I take your point, but for me, the lodgement point is one step, but I would recognise it as a document that has content which has a bearing on the resource management issues of the district. So, perhaps I'm sitting more at the end of the other of that.
In that it commits the council to do certain things under the RMA.
Well, it has a bearing on the resource management issues, and we're talking about resource management issues today, so it's probably a wider catchment for me. I am a Liberal person.
Oh, so I think the difference is where the emphasis was. So I was just looking at that relevant planning document bit, and my brain has always gone iwi management plan when I read that. And what you've highlighted is there's this back end bit which says to the extent that its content has a bearing. And so what you're saying to us is that the charter's content has a bearing on this process.
And to the extent that one document is more immediately what you think of, then that would a class higher in your weighting perhaps, but I would say that it does fit within it is captured by that also. So it was not a short point, but the next short point was a question relating to dead holes or offal pits. So they're defined as dead holes in the plan, and that is a permitted activity under Earthworks Rule 7. That's what's been recommended, but it's subject to standards.
The issue that arose was the waste that comes out of it. Is that a district council responsibility or regional council? Because it's a contaminated material.
So third short point, in terms of explanatory text, I'd just submit that issues of scope are most significant for provisions which create an enforceable outcome, such as rules, or which, using the Transpower example, create a provision which might play out in the designation process. So I would submit that where you are looking at an inclusion of explanatory text, it may not need such a critical lens in terms of scope. In terms of the question that you've asked, Commissioner Hovell, in terms of effects from buildings on skylines, I just might highlight that for me, the exclusion of protection of views is a different issue, because in the context of this hearing, the effects we're talking about on a skyline or a location are effects on cultural values, so it's under the cultural values umbrella as opposed to a protection of a view shaft. So I see it sitting under considering effects on cultural values as opposed to the views aspect. I see them separately.
So just to be clear, so you're saying that a building sitting down on the Mataura plain that is being built, that if you were standing on a public road is blocking part of your view of the Hokanui Hills, but not extending above the ridgeline of the Hokanui Hills, is a visual impact of potential concern to iwi.
And that would depend on how the provisions test that particular proposal, or if it did break the skyline. But for me, considering that proposal in terms of effects on views, that's outside what we're capturing. But in the context of this hearing, we're considering the effects on cultural values from that proposal. So it's a cultural effect, a potential cultural effect, not an impact on views.
How do you reconcile that then with the other rules in the plan that permit the planting of shelter belts and other belts that have an effect far greater?
Well, they're permitted activities, a lot of them, so they're not captured.
One of the tests that planners are asked to look at is how does the effect being looked at compare to the effects of what is permitted by other activities in the plan.
Sorry, can you repeat that one?
So one of the things that's used in assessment matters, what is the difference between the effect of potential concern versus the effect that can occur as of right through other rules in the plan?
But the effects of trees growing have potential effects on views as well.
And that you're telling me that there's a cultural aspect to the impact of a house, but surely the cultural impact also applies to planting trees.
So if we take it out of the cultural context, there's a point at which a permitted activity status has to be elected. So I would say that the election has been made by the rule to make it permitted or not. And in this instance, it's permitted to plant trees, but it's not permitted. It is in many instances permitted, but in some instances you would then consider the impacts on cultural values from a proposal. I think it's an effects question for me. It's not an effect on views that's considerable. It's an effect on cultural values.
Is it also that what you just said around the election of permitted activity status, that applies to buildings, i.e. there's a permitted envelope?
Yeah.
And so we're only talking about the bit that's outside the permitted envelope, yeah?
I guess I anticipate seeing what has happened over large swathes of Queenstown Lakes District, where developers have gone and put in shelter belts and other things along roads, so they can then come back and apply for resource consent, saying the view's already blocked.
I suspect I probably don't have a right to talk right now, but yeah, that's a topic close to my heart. And then we end up with rules preventing linear planting for that reason. But I share Ms. Chadwick's point around that the cultural impact is different to an amenity views impact, I think is the point. But yeah, you're right that there's trees could block a view, but there'd be an effects. It's not for me to say, but it may be that a vegetation view impact is different from Mana Whenua's perspective to a building. I can't speak for that, but.
Can we work it? I've got my own point of semantics to raise. So Ms. Munro Cook sought a withdrawal of the Mana Whenua and Ngāi Tahu Cultural Values chapter, and I just wanted to make it clear this panel does not have the ability to withdraw those chapters. That is a specific step which you don't have functions or powers to consider or do. This panel has functions and powers to consider and make decisions on the notified plan and submissions. So we've discussed a possible recommendation that might be made if you reach a view that there's a significant gap. In my view, that would be difficult to say about this chapter, but perhaps other ones. But again, I would submit you don't have the ability to withdraw, as Ms. Cook Munro has sought that you do.
And that would have been a matter for the council consideration last night if there was going to, or some, in other words, it would be something for that LGA setting rather than anything that we've got control over in here.
might be a bit boring, but that's a regulatory decision, and last night's decision was a local government one. So yes, it does sit with council in terms of a decision to withdraw, but it would be a decision under the RMA rather than LGA. I know that way too well now. So in terms of efficiency and effectiveness of provisions, yesterday Transpower contended that the most efficient and effective manner for them to take their stage 1 desktop analysis was by having SASMs mapped throughout the district. I would submit that that depends on different parties' views on what is effective or what is efficient. I would submit that direct engagement with Hokanui-Runanga has been proven to date and will continue to be proved to be more effective and more efficient because it is easier to work through contextual matters in person rather than by reading a black and white plan. I would also submit that the evidence that's been provided, including through Hearing 3, which I don't believe Transpower was particularly familiar with, again supports that the most appropriate and efficient and effective method is the one that the panel is considering. I do have the biggest, longest issue to talk to, and that is just to call out the elephant in the room. Today, Fed Farmers raised concerns that they're grappling with a whole bunch of information prepared for this hearing. However, this hearing has been held at this time and with these parties in response to Fed Farmers' request for a special date to be set to enable them to participate in this topic. The only date that this hearing could be set was this week, which is, unfortunately, between 2 other hearings for 2 other topics they're involved in. We are all grappling with the workload that this has created. I'd remind the panel that the request was made last year, which resulted in minute 25. A memo was then filed by council highlighting some of the procedural matters that we wanted to make sure were being dealt with openly for all parties to be involved in. A further minute was then issued, minute 28, which then gave another opportunity for all parties to be involved in the process and those procedural directions and how these things were going to be dealt with. So in my view, the consequences for us all of having a large workload for all of the hearings happening this month is in no small part because of Fed Farmers' request last year. Given the specific resumed hearing option provided for Fed Farmers in particular, in my submission it's a bit rich for Ms Cook-Munro to now arrive at the 11th hour to criticise the process. I acknowledge in saying that that the paperwork prepared for the panel on this topic has been substantial, but I would submit that it has been an appropriate response to the topic and its complexity. I'd also submit that it reflects the efforts that have been made to seek to respond to the level of concern set out in submissions. In my submission, the Council and Hokanui-Runanga and the panel have expended considerable energy seeking to respond to the evidence before the panel and identify appropriate provisions to respond to that evidence in the plan. So that is the evidence from Hokanui-Runanga setting out what we're talking about as sort of a novel or this particular approach for taking account of cultural values. We're all trying really hard to find an outcome which responds to that evidence appropriately. However, in my submission, Fed Farmers, and to a much more limited scale, Transpower has not necessarily spent as much time engaging with that earlier evidence and seeking to problem solve how that can fit, how their positions can fit in the plan provisions. While I respect that their preference is that there's lots of SASMs mapped through the district, and that doesn't respond to the evidence that we have before us in my submission, including the Charter of Understanding we've just discussed. So in my submission, taking account of the process that we've followed from A to B to C to D to get to the current version of the provisions, this has been transparent, it's been open, and it should be taken account of by the panel in considering scope, whether parties have had a fair say, and whether this has been a public process. And in my submission, all of the opportunities for input have been taken up by everyone who had the opportunity to do so. Possibly Fed farmers haven't taken up every opportunity they've had offered to them, and that's not a judgment on everyone else in terms of what has happened. And that brings me to the end.
Thank you for that additional material. I thank you for that additional material and responding to our questions. If there is nothing else looking around the room, then I will adjourn proceedings for today. I'm not going to formally close the hearing because there may be matters that come out of our deliberations that actually require us to come back. So for all those who have contributed today, the way that it's been done, the fact that we're all able, I think, to concentrate as we went through the day. It's a 9-hour day virtually that we've been through. Thank you everyone for your input, and until we meet again next week, I think it